So, hello everyone, I'm Jan Tobias. I'm one of the organizers of this thing. Welcome to this week's CIF seminar. We are in the exceptionally lucky circumstance that another organizer of the CIF seminar, namely Dr. Sofie, is going to give a talk today about compelled decryption. So that's generally the question of when the police arrests you and you have the right to be silent and you say that you have nothing to declare while they're being interviewing you and casually trying to ask you questions, how much does that actually help you when they can ask you to decrypt your phone or to give your mobile phone password or fingerprint or something like that. So that's the question for today. I'm looking forward to Sofie and Ward's talk. Sofie works currently at CIF as a postdoctoral researcher. She's involved in a couple of European projects, including the involving cybercrime and cybersecurity, and in the CIF program as well. And she defended her PhD last year in January in a pretty cool party with vegan food. And she's originally a criminal law scholar. And we also have Ward, who's doing his PhD at the Department of Criminal Law. And he's a tutor at the University of Hasselt as well, and he's doing his PhD on restricting liberties to prevent terrorism. So, Dr. Sofie, Dr. To-be Ward, the floor is yours.
Thank you very much for the introduction, and welcome to everybody on this to this seminar. As you may or may not know, October is the cybersecurity month, so we are just in time before the end of the month with our seminar on compelled decryption of IT systems. A preliminary question for this topic is what is an IT system? And in Belgian criminal procedure, an IT system is any system for the storage, processing, or transfer of data. This is a very broad definition, which includes laptops, smartphones, smartwatches, and the like, but also, for example, memory sticks, chip cards, networks, parts of networks, and accounts, such as your Dropbox or Outlook account. These IT systems, the definition being so broad, are a very big part of our lives and contain a lot of information about us and about what we do every single day. This makes them very interesting for law enforcement when an offense has been committed, because they contain lots of potential evidence. However, IT systems are very often encrypted, meaning that it's hard for law enforcement to access the information. And therefore, the question we will discuss today is, can the suspect be compelled to decrypt his or her IT systems when asked to do so by law enforcement? Just to get a preliminary idea and make sure you're all still awake after my short introduction, we have two very quick polls. First, what do you find most invasive? A, having to provide your password to law enforcement authorities. B, having your devices hacked. Or C, knowing that service providers are obliged to disclose certain information to law enforcement authorities. I propose you just type your answer into the chat. It's just like 10 seconds to think about it and type something. I'm not going to call you out or call to explain, just out of curiosity. Seeing mainly B's, a few A's, and a few C's now as well. All right. Actually, so mainly B's, but it's a little bit all over the spectrum. So opinions seem to be slightly divided, which hopefully will make for an interesting discussion at the end of this seminar. Okay, a few C's. So I think it's clear that depending on the person, some things are seen as more invasive than others. So we'll maybe see that in the discussion later. Second quick poll. Suspect X uses a password to unlock his phone. Suspect Y uses a fingerprint. Then there's 4 options. A, only suspect X can be forced to unlock his phone. B, only suspect Y can be forced. C, both suspects can be forced to unlock their phones, or D, neither of them can be forced. Here, maybe you can read can as should as well. And again, just type into the chat box. Oh yeah, a lot of these now. Okay, this is more or less unanimous. All right, so everybody until now said D, so neither of them should be forced to unlock their phones. There's a B there, but so you are more or less unanimous that they should not be forced. That's interesting because, as we will see today, sometimes they can be forced. And also, you are unanimous that both fingerprints and passwords deserve the same type of protection, which is again interesting because we'll see that that is not always the case in every country. A quick overview of today's presentation. So the introduction is obviously what's happening right now. Then Sofie will set the stage and explain the European framework regarding fair trial and the right to remain silent. Afterwards, I will give a very brief introduction to the Belgian criminal procedure and, well, in general, and also explain the rules on compelled decryption in Belgium specifically. Then Sofie will briefly compare this Belgian system to some foreign systems and also briefly discuss the use of the evidence in court. And finally, then the floor is open to you for questions and debates. Sofie, the floor is yours.
Yeah, thank you, Echt. Let's start off with some legal basics because we're lawyers after all. You've probably heard about the right to a fair trial, and if you have not, well, it's about time. So the right to a fair trial is one of the most important ones in our democratic society. It's set in stone, for instance, in the European Convention on Human Rights, but also in the EU Charter of Fundamental Rights and also in other international standards. So a lot of countries are bound by it. The right to a fair trial consists of several sub-rights. For instance, you have the right that your case is tried in a reasonable time. It comes as no surprise that Belgium has been convicted on this ground already several times. And then you also have the right that an independent and impartial judge decides upon your case. And I don't know, but maybe you remember the football case a couple of years ago in which the investigating judge had been challenged and afterwards dismissed from the case because apparently he had too close connections with the football world. And then there are several other sub-rights, but today we will be talking about the presumption of innocence. It has many names, also the right to remain silent or the privilege against self-incrimination. What does that mean? Everyone is presumed innocent until he or she is proved to be guilty. And this principle applies to criminal proceedings in respect of all types of crimes. And it means that the prosecution has to prove that a suspect is guilty and not the other way around. You don't have to prove that you're not guilty. It also means that a suspect doesn't have to collaborate with the prosecution when it comes to the collection of evidence. And the presumption of innocence is relevant throughout the whole procedure. When a judge declares someone guilty without saying why, the presumption can be violated as well. But, however, the principle does not protect the suspect against incriminating statements as such. When a suspect wants to confess, he can confess, of course. Okay, then when it comes to evidence, the privilege protects against evidence that is obtained by compulsion. What is the ratio behind this? It wants to avoid miscarriages of justice by false statements of suspects that were under pressure. So this is the reason why a suspect cannot be interrogated under oath. However, a certain degree of compulsion is allowed in a criminal procedure. For instance, a house search against your will or without your consent, or for instance, a DNA test without your consent. But how can we know what's allowed and what is not allowed? There is a lot of case law of the European Court of Human Rights about this, and I will try to summarize this for you. So the court asks 3 questions. First, is there compulsion being used? For instance, if a suspect faces a criminal or a sanction when he refuses to cooperate, this is a kind of compulsion. Other example, torture or inhuman treatment. That's not allowed whatsoever. There is a famous case of a man that was suspected of having kidnapped a child, and the police believed that the child was still alive but in lack of food. So they put a lot of pressure on the man in order to get to know the whereabouts of the child, and they threatened the man with considerable physical pain. And then the court said this is a form of compulsion. Even the threatening with torture can be considered as compulsion. Next question is whether the evidence that is obtained by compulsion is incriminating or not. Because when someone declares something under pressure, there is a chance that what he's saying is not reliable, especially when he confesses. But on the other hand, facts that are obtained by compulsion can be allowed, or exculpatory remarks as well. And then the 3rd question is whether the evidence falls into the scope of the privilege. So evidence that exists independent of the will of the suspect does not fall into the scope of the privilege against self-incriminations. A few examples are urine, blood, hair, voice prints, fingerprints, and so on. They exist independent of the will, so in that case, the privilege does not apply. Moreover, we have to accept a minor interference with our physical integrity, for instance, when a blood sample or a hair is taken for a DNA test. And then there's another famous case in which a man was suspected of drugs trafficking by swallowing these kind of plastic bubbles. And the police couldn't find any drugs on the man, so they made him swallow a substance. The substance made him vomit. The drugs that were discovered this way could not be, you could say, they exist independent of the will of the suspect, but in this case there was a violation of the prohibition of torture because this method was considered to be torture. And then documents are also considered as existing independent of the will of a suspect and can thus be requested. Then on the next slide, I made a summary. Yeah, thank you, Ert. So first question is, does the privilege apply? We know by now the 3 steps. And if it doesn't apply, for instance, the evidence that exists independent of the will of the suspect, the evidence can be used. And if the privilege applies, the court asks a new question, whether the core of the privilege has been affected. If the core has been affected, the evidence cannot be used. It depends on the nature and the degree of compulsion. And if the core has not been affected, in some cases the evidence can still be used if there are certain safeguards, and for instance, if there is other evidence that supports the case, and so on. So this is really a case-by-case approach. And then there is a lot of case law, as you can notice by now, but the European Court of Human Rights did not have to decide upon the question of forced decryption up to now. So now I give the floor to my colleague Wart, who will tell you more about the Belgian rules.
Thank you, Sofie. So, as Sofie said, over to the Belgian system now. And my story about the Belgian system starts with Peter, and this is Peter. And Peter has committed theft, let's say. As you hopefully all are aware, theft is a criminal offense and usually has a victim, being the person whose items were stolen. So let's say the victim files a complaint with the police. Then the police contact the public prosecution service, who will then start what is called a preliminary investigation. During this investigation, they can do all sorts of things, such as interrogate Peter, interview witnesses or the suspect, or the victim rather, or for example, search Peter's smartphone. They can do so as long as they disable any external connections first by, for example, activating flight mode on the phone before executing the search. If Peter's phone is encrypted, which will often be the case, the public prosecutor can have it hacked in order to be able to execute his search. If the prosecution is of the opinion that this preliminary investigation suffices and that there is enough evidence, they can move immediately to trial. And then in Belgium, there are 3 options for trial courts. In this case, theft would go to the correctional court, but that is not that important for us today. What is important is the scenario where the prosecutor rather does not think there is sufficient evidence, and he thinks that more invasive investigatory measures are required. If this is the case, then he sends the case to the investigating judge. And the investigating judge then opens a judicial investigation. And within the context of this judicial investigation, he has access to more invasive measures, such as house searches, for example, or a search not just of Peter's smartphone, but of all the connected IT systems as well. Think about his Facebook account, his email accounts, Dropbox account, etc. This is called a network search. And then also in the context of this network search, if Peter's accounts are encrypted, then the investigating judge can have them hacked in order to execute his search. So during this judicial investigation, more invasive measures are possible, but it also comes with extra safeguards. For example, Peter has the right to request additional investigatory measures, which he thinks could prove his innocence. And the case can only be referred to trial at the end of the judicial investigation after it was checked by an investigation supervision court, which goes over the investigation again, sees that all the rules were followed, etc. One of the possible measures within the context of this judicial investigation is the decryption order. Now, what is a decryption order? In the Belgian Code of Criminal Procedure, there is an article, Article 88 Quater, which contains a general duty of cooperation. And within this duty of cooperation, there are 2 possibilities. First, there is a duty of information. The duty of information, which means that people who are presumed to have special knowledge of an IT system or of the services that are used to secure the data that are saved, processed, or transferred by the IT system, those people can be ordered to provide information on the manner in which to access the IT system or the data in an intelligible form. Second, there is a duty to actively cooperate, and this means that those people can also be forced to operate the IT system themselves and to access the information themselves. Not complying with either of these duties is a criminal offense, which is punishable with 6 months to 3 years imprisonment and or a fine. Now, when the legislator introduced these duties of cooperation, he had third parties in mind, such as IT experts or system administrators, for example. And his idea was that these duties could be imposed upon them in order to facilitate the investigation. Therefore, regarding this duty to actively cooperate, the Code of Criminal Procedure explicitly states that it cannot be imposed upon suspects or their family members. The code does not do so for this duty to provide information, and so the question arose whether or not this duty could be imposed upon the suspect. Practically speaking, for Peter, this would mean that he would be obliged to share his smartphone password with the police, but he could not be obliged to input the password himself, because that would be active cooperation. Why does this decryption order matter? Because I already said that both the public prosecutor and the investigating judge can have his smartphone or his accounts hacked. However, this hacking can be expensive and time-consuming. And so the decryption order would solve this, and it's kind of a shortcut, basically, to avoid these problems. But whether or not the decryption order could be imposed upon a suspect remained unclear for years, with a lot of discussion in the literature and with lower courts ruling both ways. This situation persisted until February of this year, when both the Court of Cassation and the Constitutional Court, being the two highest courts in Belgium, ruled on the issue, and they both said that decryption orders can be imposed upon a suspect. I will now briefly explain the decisions of the two courts. I will try to do so based on the framework that, or within the context rather of the framework that Sofie explained earlier. Sadly, the courts did not structure their case or their judgment in this way. That would have been too easy. But the Court of Cassation does very clearly touch upon the different elements of the analysis. The Constitutional Court less so, but I'll get back to that in a minute. First, compulsion. So there is little argument about the fact that there is a compulsion. There's a threat of a prison sentence of up to 3 years, which could even be elevated to 5 years if the cooperation could have prevented an offense or could have limited the consequences of an offense. So there are very few people who argue that this is not compulsion. Second, though, whether or not this is incriminating, here the Court of Cassation said, well, access codes are neutral. So the court differentiates between the code itself, which it says is neutral, and the underlying information, the information on the IT system, which could potentially be incriminating. But then the court says, well, we're not asking you to give us that information, we're asking you to give us the code to the information, so the code is neutral, according to the Court of Cassation. The third step then, sorry, is it within the scope? The Court of Cassation said, well, the main goal of the right not to incriminate yourself is the exclusion of incorrect statements which were given under duress. Access codes, and this is quite important, exist independent of the will of the suspect, and furthermore, they remain unaltered by communicating them and can be verified immediately by inputting them into the IT system. Therefore, according to the Court of Cassation, there is no risk of unreliable evidence, and so there is no problem for the privilege against self-incrimination. The court added 2 more interesting points which should be mentioned. It first stated as well that current technologies make it very difficult or even impossible to access IT systems which are protected by an encryption. So the court basically said, well, this decryption order, it's kind of necessary, we need it. And secondly, the court did impose a few conditions upon the encryption order. It said it is important that the police find the IT system without coercing the suspect. it is important that it is shown that the suspect actually knows the code, so it has to be proven that he knows it. And thirdly, it is important that requested information is proportionate to the offense under investigation. That's it for the Court of Cassation. The Constitutional Court then, they also stated, much more briefly, that access codes exist independent of the will of the suspect. And then they said, which was the question before the court really, that the difference or the difference in treatment between the duty of information and the duty of active participation, the difference being that one can be imposed upon the suspect and the other can't. This difference is based on an objective criterion, being active cooperation. One requires you to actively cooperate, the other doesn't, and is thus justified according to the Constitutional Court. So there's no discrimination. So a long story short, in Belgium, the decryption order is possible, and Peter, in our case, can be forced to give the police his smartphone password. Now back to Sofie.
Thank you, Bert. These decisions of the Constitutional Court and the Court of Cassation have been criticized a lot, in fact, by legal scholars, by Bert and myself, for instance. And now I will shed light on the four main remarks. The first one being the distinction between what's incriminating and what's not incriminating. So the Court of Cassation considers the access code as neutral, but behind it there might be incriminating evidence, of course, and we find this distinction artificial. The reason why the code is so important is, of course, because of the information that is behind it, and the two are thus inseparable in our opinion. And some people say that in order to circumvent this case law of the Court of Cassation, you have to choose a password that is incriminating as such, for instance, a negationist statement, but don't tell them that we told you so. Moreover, another point of critique is that the prosecution has to prove that the suspect knows the code, but how can this be proven? Will the prosecution be allowed to rely on presumptions? So this will be a very difficult exercise. Second, both the Court of Cassation and the Constitutional Court say that the code exists independent of the will of the suspect. However, the code originates in most cases from the will of the suspect. And this is very different, in our opinion, from the situation of blood and hair samples, for instance. So this interpretation of the both courts leads to a very narrow interpretation of what exists dependent of the will of the suspect, and it can lead to an undermining of the right to remain silent in the end, because it's so narrow. And once more, it is very difficult to extrapolate all the case law on blood and hair samples on the access codes, because the Court of Human Rights did not decide upon this yet. And then third, but Bart, you can click, yeah. So third, the unreliable evidence. So one of the reasons I told you behind the right to remain silent is, of course, to avoid miscarriages of justice because of false statements that suspects do because of the pressure. But according to the Court of Cassation, there is no such risk. There is no risk to unreliable evidence, but we doubt this because there exists something such as the so-called kill codes, and we like to come back to this point in the discussion later on. And then fourth point of critique is that the Court of Cassation attaches great importance to the fact that forced decryption is proportionate to the gravity of the offense that is under investigation. But in Belgian criminal procedure, there is no lower limit. So first decryption is possible for all types of crime in principle. However, persons that face more than 3 years of imprisonment for the facts that they are hiding, for instance, in organized crime, murder, and so on, they don't have any incentive to give their password because they're facing a lot more years of imprisonment. So in our opinion, this leads to the fact that the compelled decryption order will mainly target like smaller criminals who face a lower sentence, and in that case, it's not proportionate at all. So let's move on to the next slides. Well, and have a look at other countries. So in Belgium, we know by now that the 2 highest courts approved the first decryption. And in France, the Constitutional Court did the same 2 years ago. And the court found that the goal of a decryption order is to decrypt an IT system and not to force a suspect to confess. So there was no violation of the right to remain silent, according to the French Constitutional Court. In the USA, the situation is less clear. There we have the famous Fifth Amendment, based on which no person shall be compelled to, in any criminal case, to be a witness against himself. But judges in the USA are not on the same page when it comes to applying this principle to forced decryption. Some judges say that a password is testimonial, others don't, and even for biometric decryption, it's not clear at all, the situation. And then in the UK, we have the Regulation of Investigatory Powers Act of 2000, and there is a section on encryption and encrypted evidence. And in 2008, there was a case in which a judge approved that this provision could be, or that this order could be given to a suspect in a terror case. However, afterwards, when it seems that the key was leading to incriminating evidence, then this evidence had to be excluded. So this situation is less clear after all. And then in the Netherlands, there was a draft to introduce forced decryption into the Code of Criminal Procedure, but it has explicitly been refused by the Dutch Parliament. So it has not been introduced in the act called Computercriminaliteit 3, because they considered it to be a violation of the right to remain silent. However, forced biometric decryption, for instance, your fingerprint or face scan, has been approved, and this will become part of the Code of Criminal Procedure, because they say it's only a minor interference with your physical integrity, so it can be forced upon the suspect. And then in Germany, it's not possible, the first decryption order, but there is a concept draft that aims to introduce it in the code, but it has to be still discussed in Parliament, and there would be several restrictions, for instance, only limited to serious types of crime, and so to be continued. And then let's move on to the next slide. Okay, you might remember the famous San Bernardino case in the USA, in which the FBI asked the help of Apple to unlock a phone of a suspect in a terror case, and Apple refused it, and then after a while the phone was decrypted anyhow. And now messages reach us that police departments in the USA have the capacity to break into our phones, and that they are doing more often than we previously knew. I put a link to the report on the slides that gives a description of the situation in the USA. But in Europe and in Belgium, it's difficult to know. We don't have an overview of how often this happens, because obviously law enforcement authorities are not so eager to share their information with us. And then I want to add also that in the USA, normally a warrant is required. So a warrant of a judge is required to search a phone, but in most, in the report, you can read that in most cases, suspects consent, and then their warrant is not required anymore. And apparently, when we talk to police officers in Belgium, this is the case here as well. So the consent circumvents then the stricter requirements. And then hacking or decrypting a phone is one thing, but then using the evidence in court is another thing. And that leads us to the next slide. Thank you, Ert. So this leads us to the question whether hacked or decrypted evidence is legally obtained and whether it can be used in court. In principle, if law enforcement authorities abide by the rules, the evidence is legally obtained and it can be used in court. For instance, in Belgium, they can hack your phone. There is a provision that allows it. So the evidence is legally obtained, but this can become more tricky in cross-border cases because what's legal in one country isn't necessarily legal in another one. And in this regard, the case of Encrochat is worth mentioning. So Encrochat, you might know it better than I do, is an encrypted phone network that was heavily used by organized crime. And French law enforcement authorities used the network to install malware on the phones, and in this way they obtained millions of messages, passwords, GPS locations, and so on. The French police shared it with their Dutch and colleagues and their colleagues in the UK. And then suspects were arrested, of course, and some of them have been convicted already. Some of them have pleaded guilty, and others are now challenging this evidence in court. So this is very interesting. They are arguing about the chain of custody because they haven't been given enough information for their own technical experts to contest or to challenge or to verify the data. They are also contesting the warrant or the legal ground on which the communication was intercepted. So this is a very interesting case and we are looking forward to the outcome. And so suppose that evidence is obtained in an illegal way. Can it then be used in courts? This is a case for the national judge. In fact, the Court of Justice reminded us of the fact that this is a national matter. There are no clear European rules. In a lot of countries, we have rules. As in Belgium, for instance, when the right to privacy is violated, evidence can be used in most cases. But when evidence has obtained through torture, it cannot be used, obviously. And then the European Court of Human Rights will examine whether the right to a fair trial as a whole has been respected. So if evidence has been legally obtained, it can be used. If not, the court examines whether the right to a fair trial has been respected as a whole, and it attaches importance to, for instance, whether the evidence is reliable or accurate, and whether the defense has been able to contest the evidence. And this is a case-by-case approach. So, for instance, remember the case that I told you about in the beginning of the presentation of the man that had kidnapped a child, and the man was threatened with torture, and then afterwards he has been convicted. But in this case, the statements that were obtained through torture had to be excluded, but then the conviction was valid because there was other strong evidence against the man. So it depends, it's a case-by-case approach. And in other countries, the exclusion of evidence is one way to go, but in other countries, for instance, in the Netherlands, the sentence can be reduced as well when the judge relies on illegally obtained evidence. So that's another way to go. So I have listed on the next slide some articles for you to read if you want to. And then we have some questions for you, as Swart said in the beginning. So maybe we'd like to know from you how expensive and time-consuming it is to hack an IT system, and whether it is possible to keep parts hidden from law enforcement authorities when providing your password. Can kill codes easily be implemented in IT systems? Then would you feel safer or less safe if law enforcement authorities would no longer be allowed to hack our IT systems? And finally, should a suspect who discloses his or her password benefit from a lower sentence? We would like to hear your opinions on one or all of these questions. Thank you.